Hi there. This presentation will focus on medical legal topics. Uh, there are three main topics that impact our work with patients, that being the Patient Bill of Rights, informed consent, and HIPAA. Objectives. I'm going to provide some information about the Patient Bill of Rights and informed consent, but most of this presentation will be primarily focused on HIPAA. Um, HIPAA encompasses 5 different titles that affect patient information. However, healthcare professionals are most familiar with the HIPAA title that focuses on protection of the privacy and security of the patient's medical records. I'm going to focus my presentation on the privacy aspect of HIPAA and its implications for healthcare providers. By the end of the presentation, you should be able to understand the basics of HIPAA law, be able to define confidentiality and its connections to a patient's protected health information, um, and also understand the implications that HIPAA has on patient care and our roles in clinical practice. So the Patient Bill of Rights slash Patient Care Partnership. Patient Bill of Rights is a list of entitlements a patient receives in medical care. This is the right to receive professional, quality medical care, to be treated with respect and without discrimination. The American Hospital Association, also known as the AHA, identified 12 specific areas of patient rights that the healthcare professional is obligated to respect in the year 1992. But more recently, the AHA replaced this Bill of Rights with the Patient Care Partnership. This further details that a patient understands the expectations, rights, and responsibilities while being treated and hospitalized, and you can see each details in the slide. Okay, so informed consent. It may only take place with the patient when the patient is a competent adult, making decisions by their own volition. It essentially means that the patient has been given all the information about a treatment or procedure that they are about to receive. Um, they understand the physical process of the treatment. This also means they understand the benefits, risks, and potential side effects. Information consent, I'm sorry, informed consent implies that the individual has been educated about the treatment and understands his or her choice, that has decided to pursue treatment with full knowledge of what it may entail. Okay, so what is HIPAA? HIPAA stands for Health Information Portability and Accountability Act. The federal government passed the HIPAA law in 1996. However, this law was not fully implemented into practice until 2003. Um, This was a law that created a lot of national standards to protect the confidentiality or patient information and records. Its primary intent was to ensure portability and the continuity of healthcare, or I should say, the continuity of healthcare coverage. HIPAA consists of 5 separate sections which provide more information regarding portability, privacy, and security, and its impact on health insurance coverage and healthcare practice. Um, as you can see, I have outlined the 5 titles that constitute HIPAA law. There are many nuances and intricacies to this law. So for the purpose of this presentation, I'm just going to focus on the privacy element of HIPAA and its impact on treatment providers. And you can see that in Title II, Security and Privacy of Health Data. So for patient confidentiality, in order to understand HIPAA and its impacts on privacy, we must first understand confidentiality. Patient confidentiality is a right that each individual seeking treatment is entitled to. Uh, it's a it's an ethical standard that holds healthcare workers accountable for patient information remaining secure and safe within the treating agency. Um, Often there are questions and/or requests to disclose patient information. As a result, there have been breaches to confidentiality throughout the course of history, and HIPAA was developed to honor privacy and develop standards around confidentiality. Protected health information, or PHI. So confidentiality is what keeps patients' protected health information safe and secure. Protected health information is defined as any information that can be used to identify a patient's identity. Examples of this can include age, race, gender, date of birth, phone number, address, social security number, medical record number, medical history, charts, images, billing information, insurance, healthcare proxy, etc. In order to disclose PHI or protected health information, this is where the privacy element of HIPAA comes into play. So for privacy, this portion of HIPAA requires authorization from patients to disclose personal information related to treatment. The objective was to help patients feel safe providing their sensitive information to clinicians, knowing that the information would be only released in appropriate circumstances. Prior to HIPAA, there was a lack of clarity and a lack of consistency across state and federal guidelines around the transmission of patient information. HIPAA was intended to ensure that only authorized individuals would have access to patient information. Now, if someone would like to request access to patient information, a patient would like to give someone else access to their medical information, or a patient would like to access their own record, written authorization must be obtained prior to such information. Oftentimes, each agency will have their own specific form, like a release of information, or sometimes it's called an ROI form, for a patient to complete and sign prior to the release of the information to another individual or agency. So I snagged one of the copies from Tufts Medical Center at my clinical site. So this is what in the adult medicine like X-ray area, this is what they would fill out prior to the exam. So this, like, a patient would need to complete this form and disclose any PHI to the identified person or agency. Confidentiality considerations. So with any rule, there are exceptions. I have outlined some exceptions here. It is important to keep in mind that the age and competency of your patient. If a patient is under the age of 18, obviously we can disclose information freely with that patient's parent or guardian. Once the child turns 18, a written authorization must be obtained to continue the transmission of information to the patient's parent or guardian. In addition, if a patient is above the age of 18, but has been deemed by a legal entity as being unable to make their own decisions, clinicians must consult with a court-appointed guardian or decision maker for healthcare-related decisions. Similarly, if a patient is deemed unable to make their own decisions by a healthcare provider, and there is a signed documented healthcare proxy, the physician must invoke this healthcare proxy prior to communication regarding treatment decisions. So furthermore, each healthcare provider is considered a mandated reporter, and mandated reporters are people who have regular contact with patients and are legally required to ensure patient safety and the safety of vulnerable populations. If a mandated reporter learns of imminent risk to self or a threat to harm others, this would warrant a break in confidentiality. The clinician would need to disclose this information to an agency or person to help keep the patient safe. Similarly, if the mandated reporter learns of harm to a vulnerable population, there is responsibility to disclose this to the appropriate authority, as well as like the Department of Children and Families, DCF, um, or like a local elder agency, or the Disabled Persons Protection Commission at the DPPC. And so, who must comply to HIPAA? And that's basically everyone, or should I say, all practitioners have an ethical and professional duty to maintain patients' privacy. Every healthcare provider involved in patient care and transmission of health information, health plans and insurance companies, healthcare clearinghouses, business associates that act on the behalf of a covered entity. This can include claims processing, data analysis, utilization review, and billing. So everyone. So with every law, there are limitations or downsides, and HIPAA is no exception. There are clear consequences if a provider discloses PHI without a patient's consent. However, there may be instances that are time sensitive or life threatening that is either up to a clinician discretion to disclose or require patient authorization to disclose. The law does not have as clear consequences for clinicians that do not disclose PHI when it may be otherwise warranted to do so. So, likewise, some agencies may misinterpret the regulations and may not use the law to the fullest extent. Since HIPAA does not have room for interpretation, there are still gray areas based on professional judgment. So like in the digital age, with the emergence of electronic medical records, there are some schools of thought that believe HIPAA law may need some reform for the future. So I just made like a case example. So a patient's a 40-year-old man who presents with broken arm. You just took their images and finished the exam, and then the patient takes a glimpse of the screen and asks if they can take a picture for their own sake. What would you do? What are you able to do? Do you have any considerations? So this is kind of a confusing scenario because it's the patient's own information, however, not permissible under HIPAA law. A patient must sign a written release of information, or ROI, to be submitted to the medical records department. The medical record department would then have 30 days officially to release this imaging to the patient. So no, you shouldn't let them take a picture of their own X-ray because of this. And these are my references. Thank you very much. Thanks. Bye.